Hi everyone. As many of you will be aware, on the 16th of August 2020, I set up a GoFundMe to allow me to initiate a High Court legal case challenging the constitutionality and lawfulness of the COVID-19 laws, raising some €152,000 from more than 3,300 donors across the country. These donations allowed me to engage a firm of solicitors and a senior and junior counsel at a time when many other people throughout the country were being refused legal representation. Between August of 2020 and December of 2020, I sought legal opinions from several senior counsels to determine which type of legal challenge would stand the best chance of success, and in January 2021, I settled on the action that we are currently engaged in. We formally commenced our High Court case against the state on the 2nd of March 2021 by means of plenary proceedings as opposed to judicial review. The purpose of this video is 1. To briefly explain the background to the case we initiated on the 2nd of March 2021. 2. To explain the steps we have taken in the case to date. And 3, and most importantly, to advise donors that there is a one-day hearing taking place in the High Court on Thursday, the 31st of October 2024 to decide whether or not our case will be allowed to proceed. As the state are currently arguing that as the COVID-19 laws are no longer in place, our case should not be heard. Under this point 3, I will also explain the arguments that the state have advanced and also the counter-arguments that we have made by means of affidavit and legal submissions to the court, all of which will be argued by our barristers on the 31st of October 2024 in the four courts in Dublin. The first point I would like to make is that this hearing is taking place in public. So any members of the public are allowed to attend the hearing, and in this regard I would encourage in particular anyone who has donated to the case to attend the hearing, as you have a legitimate interest in the outcome of the case. So now we will take a brief look at the background to our case. On the 20th of March 2020, the government signed into law a piece of legislation called the Health Preservation and Protection and Other Emergency Measures in the Public Interest Act 2020. And it was under this legislation that the Minister for Health was empowered to make regulations for the purpose of limiting, minimising or slowing the spread of COVID-19. These are their words, not mine. Noting that it was under this authority that the Minister for Health enacted into law regulations which closed businesses, decided which businesses were essential and non-essential, restricted travel, stopped people being legally able to visit with family, closed churches, required the wearing of face coverings and so on. The issue we took with the Minister drafting and enacting all of these regulations was that we said it was in breach of Article 15.2.1 of the Constitution, which states that the sole and exclusive power of making laws for the state is hereby vested in the Oireachtas. No other legislative authority has the power to make laws for the state. In summary, our legal action challenges the authority conferred on the Minister for Health to draft regulations under the Health Preservation Act 2020. Given that Article 15.2.1 of the Constitution states that the exclusive power to make laws for the state is vested in the Oireachtas and not a sole person such as the Minister for Health. The significance of the conferral of power to the Minister for Health is illustrated by the fact that during the lifetime of the COVID-19 laws, he signed into law in excess of 150 regulations using this authority. And in circumstances where these regulations were some of the most far-reaching in the history of the state, we said that this delegation of authority by the Oireachtas to the Minister for Health was unconstitutional. Now we will take a brief look at the steps taken in the case to date. So on the 2nd of March 2021, we served a plenary summons on the Minister for Health, Ireland and the Attorney General, seeking numerous declarations confirming that the Health Preservation Act is in breach of the Constitution. On the 22nd of March 2021, the state entered an appearance in response to our summons. On the 23rd of April 2021, we served our statement of claim on the state, noting that our statement of claim sets out in detail all of the breaches of the Constitution we are alleging. On the 13th of May 2021, the state filed Notice for Particulars, which is a list of questions that the state wanted us to answer. On the 20th of August 2021, we issued our reply to the Notice for Particulars. On the 1st of November 2021, the state issued their defence, and on the 27th of July 2022, we issued our reply to the state's defence. Then, over the next several months, we considered whether we needed to raise interrogatories or engage in discovery, but we decided against both in order to try and get the case to hearing for an early date. However, it was still July 2023 before we were ready to have the case set down for hearing, and in this regard, we issued a certificate of readiness on the state at the end of July 2023. Once the certificate of readiness had been served, the other side had 30 days to provide details of any witnesses they intended to call, and also to confirm that they agreed or not with the trial estimate that we had set. It was only after these issues had been agreed that the certificate of readiness could be lodged with the court, and thereafter that the court could set the actual date for the hearing. So by July 2023, we had undertaken every step in the legal proceedings to allow the case to be called on for hearing, which in terms of how long it normally takes a plenary High Court case to go through all stages would be considered quick. This was the point at which the state started to engage in tactics to stop the case being heard. So from July 2023 onwards, every document issued by the state was an attempt by the state to stop the case being heard, including amending their defence in November 2023 to say that we had abused the legal process by using plenary proceedings instead of judicial review. I will explain what this means shortly. Thereafter, in January 2024, the state issued a motion to the court asking for our case to be dismissed, A, as they alleged that it constitutes an abusive process, and B, on the basis of mootness. I will also explain what this means shortly too. At this time, as in January 2024, the state also filed an affidavit setting out why they believed our case should be dismissed, to which we responded in April 2024. The state then issued a legal submission in May 2024, setting out what they allege is the legal basis to have our case dismissed, to which we responded in July 2024. The hearing on mootness was initially scheduled for July 2024, but was later scheduled to the 31st of October 2024, as there was no judge available to hear the case in July. So just to be clear, the hearing taking place on the 31st of October 2024 is in response to the motion filed by the state in January 2023 to determine whether our case is an abusive process or moot, or whether our case will be allowed to be heard. If the court finds in favour of the state, our case will be dismissed, and if the court finds in our favour, a hearing date will be set to determine whether or not the COVID-19 laws were unconstitutional. So in the final part of this video, we will discuss the arguments that will be made by the state on the 31st of October and the arguments that we have already advanced by means of affidavit and legal submission in rebuttal. The first claim made by the state is that the case should be dismissed because A, I failed to bring an application for judicial review. B, the time inside which I could have brought an application for judicial review has long expired, given that JR proceedings must be initiated within 3 months of the alleged breach. And C, that because the time inside which I could have brought an application for judicial review has expired, I am now trying to abuse the legal process by initiating plenary proceedings. The first point I would like to make about this argument is that I have no doubt whatsoever that this argument will fail, and this is primarily for 2 reasons. The first is the fact that the state made the opposite argument in the Gemma O'Doherty and John Waters case in 2020. In that case, the state argued that Gemma and John should have proceeded by means of plenary proceedings and not judicial review. In this regard, please see paragraph 43 of the judgment of Justice Meehan delivered on the 13th of May 2020, which states the following. Mr. Patrick McCann SC, on behalf of the respondents, submitted that the applicants adopted an incorrect procedure in bringing these proceedings to have the legislation declared unconstitutional. The correct procedure was to bring an application by way of plenary proceedings, not judicial review proceedings. Also see paragraph 49 and 77, which state the following. On the issue concerning the procedure followed by the applicants in challenging the constitutionality of the legislation, I accept the submission of the respondent. However, were I to reach the conclusion that the applicants had established an arguable case, I believe that the correct course of action for me to take would be to order that the proceedings continue as if they had been begun by plenary summons. the applicants have sought to challenge the constitutionality of certain legislation enacted to combat the COVID-19 virus. They also challenged the legal standing of the government and the procedures followed in the Oireachtas in the passing of this legislation. Such an application should have been brought by way of plenary proceedings, not judicial review. So, to be clear, in the Gemma O'Doherty and John Waters case, the state argued that the correct legal process was plenary proceedings and not judicial review, and now the state are trying to argue the opposite. Also, to be clear, in that case, Judge Meehan found in favour of the state and confirmed that the correct process was in fact plenary proceedings, noting that this judgment was delivered on the 13th of May 2020 and we initiated our legal case by means of plenary proceedings on the 2nd of March 2021, and the primary reason we proceeded by means of plenary proceedings was because of the judgment in that case. Finally, just to say that my preference would have been to proceed by means of judicial review because my case would have been heard in a fraction of the time frame, but I was more concerned with our case being successful than our case being heard quickly, and this is the reason that I ultimately chose plenary proceedings over judicial review. The second reason I believe the state's judicial review argument is bound to fail is because it is objectively clear that we never intended, nor did we abuse the legal process by trying to circumvent the JR timeframe of 3 months. As stated earlier, the Health Preservation Act was enacted into law on the 20th of March 2020. The part of this Act that we are alleging is unconstitutional is Part 3, and the Minister for Health was empowered to make regulations under this Part 3 until the 31st of March 2022. And prior to the 31st of March 2022, we issued our plenary summons. The state entered their appearance. We served our statement of claim. The state filed notice for particulars. We issued our reply to the notice for particulars, and the state issued their defence. Given that the time frame to initiate JR proceedings is quite short, being 3 months from the date of the alleged breach, it is sometimes the case that a plaintiff will be outside of the 3-month time frame and therefore will decide to initiate plenary proceedings to try and circumvent the 3-month JR window. But this argument of circumvention and abusive process only holds water if the plaintiff in question is actually outside of the 3-month window, which we clearly were not. Given that the state enacted more than 150 regulations between March of 2020 and March of 2022, and during this time we not only initiated plenary proceedings, but had completed all steps in the proceedings up to defence stage. So the argument that we were trying to circumvent the 3-month JR timeframe by issuing plenary proceedings instead of judicial review is frankly farcical. For these 2 reasons, I have no doubt that this element of the state's motion will fail on the 31st of October next. The second claim made by the state is that my case should be dismissed because my claim is moot. In this regard, the state are arguing that as the authority for the Minister for Health to draft regulations under the Health Preservation Act expired on the 31st of March 2022, A, there is no live dispute between the parties, B, any judgment made by the court would be academic and confer no material benefit on me, and C, the hearing of the case is not an appropriate use of the court's time, as the state believes that the case would take up to 8 days to be heard, as they intend to call numerous expert witnesses. In brief, the doctrine of mootness is applied by the courts to stop people seeking what they refer to as advisory or hypothetical answers to questions of law, by insisting that there must be some live controversy between the parties, such as a law that is currently being enforced by a defendant on a plaintiff. That said, there are exceptions to the doctrine of mootness, including that a case is of exceptional public importance, that the case may act as a test case for matters that may be pending before the courts, or that the dispute between the parties is capable of repetition. In particular, the state have argued that the law on mootness was recently considered in the context of the COVID-19 pandemic in the Declan Ganley case, which was an application brought by way of JR challenging restrictions imposed on the practice of religion under the Health Preservation Act 2020. By the time Declan Ganley's case came on for hearing, the regulations that he was challenging had expired and his case was therefore dismissed by Judge Meehan on the grounds of mootness. The state have gone to great lengths to liken our case to that of Declan Ganley. However, we are not challenging one or two specific regulations, but all regulations under the Health Preservation Act and the Act itself, to illustrate the totality of the authority conferred on the Minister for Health in breach of Article 15.2.1 of the Constitution. So next I will outline the arguments we have made in our replying affidavit and legal submission, and which we intend to argue before the courts on the 31st of October next. The two main arguments that we have advanced, both of which are exceptions to the doctrine of mootness, are A. That the dispute between the parties could be repeated because similar laws could be introduced into the future, with evidence for this including 1. That the Minister for Health stated in June 2022, after all regulations had lapsed, that he was considering reintroducing laws to require the wearing of face masks once again. And 2, the fact that the government had stated their intention to sign Ireland up to the World Health Organization Pandemic Treaty and amendments to the International Health Regulations 2005, which would have granted the Director General of the WHO the authority to declare future pandemics, thereby illustrating the belief not only of the Irish government but worldwide that future pandemics are a certainty, and once a future pandemic is declared, legal restrictions will quickly follow. And B, that our case is of significant and exceptional public importance for the following reasons. 1. The type and length of legal restrictions imposed on otherwise lawful activities, noting that I and all other persons in the state were at risk of criminal prosecution for nearly 2 years, 716 days to be exact, for activities that outside of wartime had never before been made illegal, including the following: prohibiting the free exercise of religion, curtailing the right of assembly, prohibiting access to any other private dwelling, restricting the holding of and numbers attending public events, restricting the number of persons who could attend weddings or funerals, restricting free association by citizens, arbitrarily declaring large number of businesses as non-essential, prohibiting residents from travelling outside of the state, imposing de facto house arrest on citizens, and confining citizens to strict geographical zones. 2. The significant number of criminal sanctions imposed on persons under the Health Preservation Act, including the following: some 12,800 prosecutions, some 22,000 Garda imposed fines totalling more than €4.7 million, sentences of imprisonment on up to 70 persons, and additional fines imposed by the courts totalling €776,000. 3. The fact that the Health Preservation Act constituted an unprecedented interference with not only my rights but with the rights of all citizens of the state, noting that there must be an effective remedy for the protection of rights that are guaranteed under the Constitution. 4. The unprecedented, unbound and extraordinary breadth of delegation of authority to the Minister for Health to make regulations over such broad areas of human and social activity, noting that the Health Preservation Act 2020 granted unspecified, indiscriminate and unlimited powers to the Minister for Health to make regulations for any other measures that the Minister considers necessary in order to prevent, limit, minimise or slow the spread of COVID-19, and that the Minister for Health used this particular provision of the Health Preservation Act as a blank cheque to draft regulations that had never been sanctioned or contemplated by the Parent Act, including the following: the introduction of a reasonable excuse test to determine if citizens could leave their homes, SI 121 of 2020. The prescription of businesses and services as essential retail outlets or essential services or not, SI 121 of 2020. The promulgation of passenger locator forms, SI 181 of 2020. The introduction of the substantial meal requirement, which required that members of the public would not be granted access to any business or service selling or supplying alcohol for consumption on that premises unless they ordered and consumed a substantial meal worth €9, SI 234 of 2020. The imposition of mandatory face coverings on public transport, SI 244 of 2020. The imposition of mandatory face coverings in certain businesses and premises, SI 296 of 2020. The imposition of limits on numbers of persons attending funerals, SI 297 of 2020. The imposition of limits on numbers who could attend weddings, SI 701 of 2020. The introduction of paired households, whereby one household would agree with one other household that each household would be treated as a paired household, thereby allowing them to attend events in each other's homes, SI 701 of 2020. The imposition of a requirement to produce COVID-19 test results on arrival into the state where the person concerned was not an exempted traveller and where the person arriving in the state had been in a relevant state during the period 14 days prior to the date on which he or she arrived in the state, SI 39 of 2021. The imposition upon certain persons of self-quarantine upon arrival in the state, SI 39 of 2021. The imposition of a requirement whereby a relevant traveller who was 1. More than 7 years of age and less than 18 years of age, and 2. Not accompanied by a responsible person, could not travel to the state without having a relevant test result, SI 135 of 2021. The imposition of obligations on travel organisers to refuse to organise the travel of persons to the state where the person had not, to the satisfaction of the relevant travel organiser, demonstrated that he or she had a relevant test result, SI 135 of 2021. And the introduction of ad hoc lists of events permitted to take place inside the state and the maximum numbers of persons allowed to attend such events, including the likes of the following: that 1,000 people could attend a Shamrock Rovers versus Drogheda game, that 200 people could attend an indoor concert, that 2,500 people could attend an outdoor golf tournament championship, and that 3,500 people could attend a music festival, SI 304 of 2021. It's actually crazy when you recall the type of measures that the government were enacting in law. 5. The overall responsibility of the courts to preserve constitutional safeguards and the exclusive lawmaking authority of the Oireachtas be not eroded by a delegation of power, neither contemplated nor permitted by the Constitution. 6. That declaring this case moot would have the effect of telling the Oireachtas that provided a sunset clause was included in legislation, thereby making the legislation temporary in nature, that this would somehow render the legislation immune from review by the courts, regardless of how significant or geographically widespread the restrictions on civil liberties might be. 7. The constitutional right to access to the courts for all citizens. And 8. The lack of parliamentary oversight when regulations were being enacted, which was raised by many TDs as a particular area of concern and which resulted in several TDs bringing forward a private member's bill titled Health Parliamentary Oversight of Certain Instruments Relating to COVID-19 Bill 2021. Now, it's clear that I believe that this case is of significant public importance. However, it's also worth noting that wide groups of people, including the government itself, TDs and NGOs, all considered the restrictions imposed through the Health Preservation Act to be both significant and unprecedented, with some examples including the following. A. The preamble to the Act itself states that it is an act to make exceptional provision in the public interest, and that an emergency has arisen of such character that it is necessary for compelling reasons of public interest and for the common good that extraordinary measures should be taken. B. A 92-page report prepared by the Irish Council for Civil Liberties in May 2021 titled Human Rights in a Pandemic, which states the following. We must continually remember just how far-reaching these restrictions have been. They go to the heart of our democratic society, bringing the state and the Gardaí into regulation of ordinary life. This unprecedented situation has given us a glimpse into the experience of other regions of the world where police checkpoints, curfews and criminalisation of community activity are commonplace. our democracy has been strained. While the government and Oireachtas did not move to entirely suspend rights, as some other states did, the Minister for Health was given incredibly broad powers to restrict human rights. In particular, the two ministers over the pandemic period introduced an extraordinary range of regulations criminalising aspects of daily life. C. A 62-page report prepared by the Irish Human Rights and Equality Commission in February 2021 titled Ireland's Emergency Powers During the COVID-19 Pandemic, which states the following. The powers delegated by the Health Preservation Act are sweeping in respect of the conduct that may be prohibited by the Minister by regulation, and the effect on rights is potentially vast. And finally, D. A 22-page paper written by TD Jim O'Callaghan in April 2022 titled Emergency Powers and the Executive, Reflections on the Past and a Vision for the Future. Now, it's important to remember that Jim O'Callaghan has not only practiced as a barrister since 1993, so he is well familiar with law, but he is currently and was the Fianna Fáil spokesperson on justice throughout the COVID-19 pandemic. So his views on the laws enacted are particularly relevant. So here are some of the statements that he made in this paper that he drafted in 2022. For nearly 2 years from March 2020, extraordinary restrictions were imposed upon the lives of people living in Ireland. Measures that were never previously contemplated were introduced. The measures introduced were the most significant interference with the liberty and free movement of Irish people since independence. The regulations signed by the Minister for Health prescribed what was permitted, but what was even more significant were the daily activities that were now implicitly prohibited. For example, all schools, colleges and places of learning were closed, depriving children and adults of attending their educational establishments. All forms of sporting activity, outdoors as well as indoors, were stopped. Children were no longer permitted to play with their friends. Socialising with those outside of your household was not permitted. Ireland's political response was moulded by what happened in China. The fact that China is an authoritarian regime that does not afford respect to the fundamental rights of the individual, in the same way as is done in this country, was ignored when Ireland and other European countries decided to replicate the Chinese response. In conclusion, on the 31st of October 2024, the state intends to ask the court that our case be dismissed on the basis that there is no live dispute between the parties. And in this regard, it naturally follows that the state is of the view that the laws imposed during the COVID-19 pandemic, which, in the words of TD Jim O'Callaghan, were the most significant interference with the liberty and free movement of Irish people since independence, do not represent an issue of significant public importance. Well, my message to the state: I, the non-compliant, the coerced, the people you jailed, the people you fined, the people you detained, the families you ruined, the people whose businesses you destroyed, and many others who were persecuted by these laws would beg to differ. Please be assured that we will do our best on the 31st of October to advance all the arguments that I have laid out in this video, and I want to thank you for your support to date, and thanks for listening.